Welcome to Cordell and Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Everyone, welcome to the Men's Divorce Podcast. I am Kristin Zurek, a senior litigation partner from our Town and Country, Missouri office. I have Asa Neff with us today. He is a senior litigation and attorney from our Albany, New York office. Asa, welcome.
Thank you for having me today, Kristin.
I'm excited you're here because we are going to talk about mental health and the effect that it has on custody cases. Why do you think this is an important topic that we need to share with all of our viewers?
Well, more and more, the courts have recognized the significant impact mental health has on custody determination. And over the years, we've seen some evolution in how the courts will treat mental health. I think it's really important that we take an opportunity to explore those different aspects of this area, and as it affects custody, whether we're representing somebody who's experiencing mental health issues or whether we're representing someone whose ex is experiencing mental health issues.
So, Asa, I'll be the first to tell you, in my state, the mental and physical health of both parents is absolutely written in as a determining factor in my statutes. How do the courts in your area deal with it?
Absolutely the same. So in New York, the courts are going to consider the fitness of the parents, and mental health is a major aspect of whether or not a parent is fit. Also, the safety of a child is of utmost importance. And if there's an issue that can impact the safety of a child, that's going to be a fundamental area that the courts are going to want to explore before they issue any final determination on custody or whether or not they're going to modify custody.
So, Asa, before we jump into these specifics, I do want to bring up a question. I do a lot of the intakes in my office. I'm sure in your career you've met with a lot of clients as well. When a client sits down and tells you, my ex is crazy, how do you deal with that information? How do you suss out what is their opinion versus what may actually be a legitimate diagnosis?
So that's a great question, because it's not uncommon for people to make those types of comments, to make those kinds of statements, and it is important to really get to the bottom of whether or not you just feel somebody's acting a certain way and whether there's been a clinical diagnosis. So usually it's a follow-up question. My ex is crazy. Okay, well, to your knowledge, have they ever been diagnosed with any kind of mental health issues? To your knowledge, are they taking any medication? How regularly are they going to see counselors? And from those types of questions, you can really get a sense of whether there's something that's been diagnosed, but then further, and whether maybe there's something that's undiagnosed. As attorneys, we deal with these issues regularly, and there are questions we can ask and things that are being said that can really show us that maybe there is an underlying mental health issue that may have been so far undiagnosed that's going to need to be explored.
That's a really good point. So my other question before we get into the specifics, Asa, is what happens if you have a client that you believe has already done the research? They've spent all their time, they have their Google psychology degree, and come in and say, I am convinced she has narcissistic personality disorder and prove me wrong.
So then it really moves into another question, and that's, how is this impacting the child? How is it impacting custody? Because having an underlying mental health issue is not in and of itself a reason to impact custody. Somebody can have these issues, and if they're maintained, if they're properly treated, they could still be a great parent. So the real follow-up has to be, okay, if they're showing these types of tendencies, how is it impacting their ability to be a safe and appropriate parent for the child. And if we get a lot of examples of how the child has been neglected, about how the child is being told things that seem completely outside the basis of reality, then those are things that are impacting custody and will need to be addressed. If somebody's having episodes, but it's not impacting the child, then it may not have the same impact on any future custody determination or be the basis for modifying custody.
So a child-centered approach in making those kinds of concerns to your lawyer or to the court is a lot more successful than just a slanderous, she's crazy, she has this problem.
Agreed. If we're talking about a divorce, those are all reasons that you might want to seek a divorce. My spouse is acting in such a way and I just can't be a part of that anymore. But when we're talking about custody, it's a different analysis. It's really, how is it impacting the child? Because that's what the court's going to be most centered on when we're looking at a custody determination.
So, Asa, what happens if we have a potential client coming in the door who does actually have a diagnosis? And they let us know in the first meeting, yes, I've been diagnosed with bipolar 2. How is this going to affect my chances of getting some custody of my kids?
So that's never a simple answer because we need to then do our due diligence and confirm that if they have this diagnosis, that they're doing everything they need to in order to treat it. Because I mentioned already, having an underlying mental health issue does not prohibit somebody from being an appropriate parent and being a safe parent. So we want to get ahead of those issues. We're going to ensure that they are treating with appropriate providers, a psychologist or a psychiatrist. We're going to want to get all the records that are in place already, confirm any medication that they're taking, confirm that they're taking those medications as directed, and try to get way ahead of that issue. So when we go in front of a court, we can say, yes, there is a diagnosis, but it's being treated and our client is maintaining, and he is not a danger to himself, a danger to the child, and is an appropriate parent. Now, if we have somebody come in and they've had these diagnoses, but there's been lapses, there's been breakdowns, there's been incidents, then it's something else, because we're going to want to encourage our client to do all the things that they will need to do in order to show the court that, yes, these things have happened, we've had these incidents, these episodes, but now we're on top of it. We've made whatever changes need to be made to medication. We've increased therapy or counseling. And here are all the records of what steps we've taken in order to make sure our client is safe and appropriate.
So, Asa, let me bring up the point that I'm aware, and I'm certain most of our listeners or our viewers are aware, that the records that you're talking about, the medication records, the counseling records, the psychiatry records, are protected by HIPAA. How do we get comfortable having the client share that sensitive information with us, and then in turn share some of that information with the court?
That's a great question, Kristin, because counseling and therapy only works if you're open and honest. And it's a waste of time if somebody's going to go into therapy worried that what they say is going to come back and be used against them. So what we will often do is sign a limited release. So it's still a HIPAA form, it's still a release of information, but it limits the information that's being disclosed to confirm that the patient is in treatment, cooperative with treatment, taking medication as prescribed, but not disclosing the details of notes from sessions, because those are things that need to maintain confidentiality. Otherwise, the counseling is never going to work and it's counterproductive. So whether it's our client and we want to protect their information and limit that release to simply recommendations and confirmation, or if we're asking for that information from the other party, really the goal is to confirm that the patient is stable, is cooperating, is following treatment, and taking their medication appropriately. So with that limitation, you're able to do both things. You're able to maintain the confidentiality that we want to maintain, but also provide the assurances to the other party, to the court, that everything that we say they're doing or we need to see that's being done is being done.
So Asa, is this something that the client would work through with you directly as his lawyer, or is that something the client should work through with his provider?
So that's both. The attorneys will often prepare the releases, work with the provider, and ensure that the information that's being disclosed, if it's our client who's disclosing the information, is appropriate and not a HIPAA violation and not providing information that isn't appropriate under the circumstances. It's very important that an attorney who's representing has their hand in monitoring what's being disclosed, and that there's nothing, whether intentional or inadvertent, that's being disclosed and might violate our client's confidentiality.
That's a really good point. Let's talk about the flip side of the coin. What happens if we're meeting with someone who sits across our table and the allegation of my ex is crazy or my ex has a diagnosis is actually backed up? They have some medical records to prove that.
So what we want to do is look at the medical records, and it goes back to the question of how is this impacting custody. But certainly, if there's been an impact, if somebody's having a mental health breakdown and there's a danger, then there's a lot of things we can do. And I've had clients come into my office with an emergency situation. My ex is having a complete mental breakdown. The child is in danger. What do we do? And the first thing we do is try to get an order of protection in place, because if a child is in danger, the courts are there to help. And whether this is going to be long-term or very temporary, we'll work with our clients, go to the court, and do everything we can to protect the child. And at that point, it's a matter of providing all the records that are necessary, reviewing all those records, and then going through the same exercise. We want to ensure the other party is getting the treatment that is necessary, that they're staying with that treatment. So in cases like this, if we can get the other party stable and in a safe place, and we're going to ease some restrictions, what we'll often do is keep a limited release in place, sometimes indefinitely. So the court or the other party is able to receive regular confirmation from a provider that the other party is continuing in treatment, continuing to be stable. And if there is a problem, those providers have an obligation to disclose that problem so there could be intervention before it turns into a dangerous situation.
So Asa, what happens when when even though we may have a diagnosis, we're still concerned about the effect that the mental health diagnosis has on that person's ability to parent the child? What is the usual trigger for a psych eval or a custody eval? And what does that process look like?
So if we're looking for what we might call in New York a forensic evaluation or a psych evaluation of the other party, we need to show that there's been some correlation between someone's diagnosis that they have that's either been documented or is yet undocumented, and some incident that's happened with the child. Somebody's been neglected, someone's been abused. But with those assertions, the courts want to ensure everybody's safe. That's really one of the primary responsibilities of a family court judge. And when you bring these concerns and you're able to provide evidence to the judge that something has occurred, a court can order either party or both of the parties to undergo a full psychological evaluation. And those can be invaluable to give the court a full picture of really what's going on. Once we have that evaluation, then you can make a further determination of what might be appropriate in custody. But first and foremost, the court's going to want to see what the diagnosis is. And if there's been a real incident, if there's been a real danger, it's not uncommon for there to be protections put in place, an order of protection that will ensure the safety of the children. Now, that doesn't necessarily always mean that there's no contact. There can be protections in place that include supervision, and that can be supervision by a family friend, a family member, or in some cases, it can be at a facility that offers those types of services. So there can still be contact. We just want to make sure that it's safe under the circumstances.
So you keep mentioning the word safe from the court's perspective. Do you believe that mental health in these cases, the courts are always trying to address and fix what they can fix or put in safeguards if they can't fix it?
That's correct. So what I tell clients is that courts want parents to be involved in their children's lives. The courts aren't there to try to separate kids and parents, just the opposite. But yes, they want it to be safe. So the goal is to try to get anyone who might be experiencing issues to a place where they can get to a safe relationship with their child and have a safe environment. It's just a matter of, and every case is very unique, every case is very, very particular to the situation, but we want to find ways to ensure the safety of the children. And how we get there, that depends on the specifics of any case, but that is the ultimate goal, ensure the safety of the children.
Now, what else happens, Asa, if you have a litigant, either someone we're representing or someone who's on the other side of the table, who is at the severe end of a mental health concern, where they are struggling to understand, struggling to understand the litigation, struggling to make good choices, struggling to be a good parent? What happens in those situations?
So in the most severe cases, like you're really describing, where somebody's not even able to understand that they have this severe of an issue, then there can be the appointment of a guardian. And we in New York call it a guardian ad litem, where the court will appoint usually an attorney to make decisions that are in the best interest of a party who is not able to make those decisions for themselves. So if somebody is having a mental break and they're still asking for relief that simply would not be appropriate under the circumstances, or if they're not cooperating with recommendations that are being made, then the court can appoint a guardian to help guide those decisions for them. But once again, hopefully that's a temporary fix to where somebody can get the treatment they need and be in a better place to make decisions on their own.
And those are really, really remote instances. Is that fair?
That's more than fair. In my 15 years of practicing law, I think I've had 2 clients it was determined that simply could not make appropriate decisions for themselves. And the court agreed and appointed a guardian to help guide those decisions. It's not something an attorney or a court will take lightly. And again, not something that's intended to be long-term. But when you do have somebody who's in a situation where they just have such a break from reality that they're not able to make decisions that are in their own best interest, then those steps can be taken and in some cases are appropriate.
So Asa, we're talking about some really serious things, and my intent here is to not freak out people that are listening to this. Can you give us an example that you've seen in any one of your past, cases or past fact patterns you've seen come through your office where there's been a mental health break, there was a safety concern, and then it was addressed?
Certainly. I've had many, many cases where we've had success in coming back from a mental health break. I had a case very recently where someone came in and it was very well documented that they were prescribed certain medication that had the opposite effect, which isn't uncommon with certain types of drugs that are prescribed for mental health. They can have the opposite effect. And on this medication, they were paranoid, they were suicidal, and they were dangerous. They were a danger to themselves and a danger to others, and an order of protection was put in place. Now, we were able to identify that issue through proper treatment. The medications were adjusted. Through counseling, it was determined that was the cause of the break that had occurred. And we were able to show to the court that there had been a certain level of stability since the change in medication was made. The order of protection was lifted, and the custody schedule that had been in place went right back into place. So it's never the end of the world when these things happen. It's just a matter of identifying the cause and taking the right steps to address those to ensure everybody, once again, the safety of the children. So we do have success in overcoming these things. It's just very important to have an attorney working with you with experience in these matters that can help guide you through the system, because they are difficult issues.
Is there a flip side of the coin? Have you seen where there was a mental health misstep and it did impact custody in a negative way?
So absolutely. I've had cases where the other party was having these terrible breaks, but it became very difficult to document them appropriately. The courts were reluctant to take away custody from someone without proper documentation, and the allegations that we're putting forward the court didn't find substantial enough to interfere, and it had terrible consequences. Those things will hopefully ultimately be corrected before anybody is injured, but these are hard issues, and they're difficult for the court as well. Courts can be very reluctant to interfere with somebody's rights. So once again, it's important to have the strongest arguments possible when you're going into court, and we in the courts will do everything we can to try to protect the children and make sure everybody's safe.
So, Asa, I appreciate your input on all of this. What I'm taking from our conversation is that a potential client, when faced with these concerns, really does need to work closely with their counsel and with any mental health providers on their side, or potentially seek mental health providers if the opposing party has an issue, to address the safety concerns that the court very well may have. Is that fair?
Yeah, I agree. We become a team. And if it's our client with the issues, we're working very closely with their mental health professionals to ensure that we can get the proper treatment and also the proper documentation to show the court and protect our client's interests. On the other side of it, when the other party's the one having the issues, we're going to make sure that we get all the documentation that we need, work with our client, and put together a plan to make sure that we have the strongest arguments possible. This really becomes a team effort between our clients, the professionals, and the court to do everything we can to make the strongest arguments possible.
So whereas mental health is a very, very serious concern, it's still a concern that us attorneys at Cordell are very skilled in dealing with, and we're able to help you guys with any situations that may arise. So I want to thank you, Asa, for your time and your expertise, and thank you all for listening today.
Thanks, Kristin.